Before I introduce our luncheon speaker, I do want to offer a few notes about upcoming programming that the center has had or will be having soon. Some of you joined us a few weeks ago for our conference Beyond Deference on emerging issues of judicial review. Obviously, this event is on the First Amendment free speech. We'll have two interesting conferences in the fall based on research that's being formulated and developed right now. Will be discussed at some private workshops this spring. One on permits and licensing and government approvals and that aspect of the administrative state. The other private workshop, public conference in the fall, will be on religion and the administrative state. We've got some really great papers coming up on that, including one by Helen Alvarez of the George Mason Law School. Speaking of which, I do want to thank the George Mason University Scalia Law School and the whole team here for supporting our program and for supporting this event, from the AV team to the folks who are bringing us lunch and so on. But also I want to thank, of course, Leah Verbitsky, who keeps all the trains running on time. And I also want to thank the law students that are helping us today. Caroline Brothers, Tommy Rucker, and Daniel Shapiro, thank you very much for all your support on helping this program run along. Two other events I want to bring your attention to. They haven't been publicly announced yet, but they will be soon. So if you're not on our mailing list, if you're not tracking our website, please do keep an eye out for these. On April 6th, we're going to have an event on Capitol Hill. It's going to be in the Senate Russell office building in the Kennedy Caucus Room. We're going to have a program, a half-day program on Congress and the administrative state, Congress's powers, responsibilities, and possible reforms. We'll be discussing everything from the oversight process to the appropriations process and how all of this interacts with the administrative state. So hopefully that'll be a good program. On April 10th, we're going to be in New York, a commute, I suppose, for the local folks, but if anybody's watching online, we're going to have a program in New York City, co-sponsored with the Manhattan Institute, on current issues in regulatory reform and financial regulation. So that will be on April 10th. And with that, let me introduce our luncheon speaker, Stuart Taylor. Stuart Taylor is one of the nation's leading authors and journalists on the courts, the Constitution, and American politics. Earlier in his career, he covered the Supreme Court and legal issues for the New York Times, the American Lawyer, National Journal, Newsweek, the Atlantic Monthly, and other publications. In recent years, he's authored three important books on law and American society. In 2007, he and Casey Johnson published the definitive account of the Duke lacrosse rape accusations, titled Until Proven Innocent, Political Correctness and the Shameful Injustices of the Duke lacrosse rape fraud. Stuart, tell us what you really think. In 2012, he and Richard Sander published an influential study of examining the effects of affirmative action in our colleges. It's titled Mismatch: How Affirmative Action Hurts Students and how it hurts students it's intended to help, and why universities won't admit it. Again, I won't spoil the ending. You have to buy the book to find out what's in it. And most recently, in 2017, he and Casey Johnson teamed up again to publish Campus Rape Frenzy: The Attack on Due Process at America's Universities. He continues to report on issues of free speech, university bureaucracy, and federal regulation, obviously all relevant to the issues before us in today's conference. So please join me in welcoming our keynote speaker, my friend Stuart Taylor.
Good afternoon. I have to move this down a little bit after Adam. Thanks to my old friend Adam for inviting me to speak to you, and also thanks to my older friend Michael Grieva for every minute he allows me to speak before he growls, 1 minute. So I'll get started. I'm talking about free speech in the administrative state in the sense that I'm going to focus on one little side of it. The frontal attack on campus free speech that the Obama administration launched a few years ago in the name of combating alleged sexual harassment, a phrase often applied to all kinds of constitutionally protected speech, ranging from ugly slurs to innocuous jokes to honest debate. This attack on free speech was twinned with the administration's, I'd say, better known attack, better known now, on due process rights of male students accused of sexual assault, starting with the now infamous 2011 Dear Colleague letter. These policies were not the work of faceless bureaucrats. They were led by politically appointed ideologues in both the Education Department's Office of Civil Rights, OCR, and the Justice Department's Civil Rights Division, with strong support from Vice President Biden and President Obama personally. The policies sprung from ideological seeds planted in recent decades by student activists, academic administrators, professors, politicians, and journalists. Indeed, many universities were attacking free speech as well as due process long before the Obama civil rights team made mandatory both censorship and guilt-presuming disciplinary rules for accused males. The effect of the Obama administration decrees on a campus culture already steeped in both censorship and political indoctrination has been pernicious. Outrageous and often unconstitutional injustices to independent-minded students and professors proliferated beneath the radar for decades because they were largely ignored by the news media. The media, of course, tend to combine glorification of their own constitutional rights with indifference to or even approval of attacks by their ideological allies on the rights of others, especially on campuses. Lest I seem to be unduly picking on the Obama administration and the left, I stress that there's every reason not to trust President Trump to protect free speech or due process either. Indeed, to quote Reason magazine, which is now has the new luster of the Volokh conspiracy blog, indeed, to quote Reason magazine, Trump and many of his supporters have shown themselves to be at least rhetorically committed to, quote, eliminate First Amendment rights on the football field, revoke citizenship for flag burning, pull broadcast licenses over bad comedy sketches, and expand libel laws to take down annoying members of the media. This last begins to bother me more now that I'm writing mostly on my own behalf. I studied book contract, and they're not going to bat for me if somebody takes after me for libel, and you know the legal fees are pretty tough. But Trump notwithstanding, Education Secretary Betsy DeVos and her team have been courageous and wise in their efforts to end the Obama administration's pressure for colleges to trash due process and censor protected speech. I'll sketch in a few minutes the need for DeVos to go well beyond wiping out bad Obama policies in an era when politically correct universities will otherwise continue to trample free speech and due process. First, I'll detail, as an example of bureaucratic tyranny at its worst, how the two major Obama civil rights agencies used an investigation into alleged rapes at the University of Montana to launch a surprise attack on campus free speech, one with roots in the 2011 Dear Colleague letter and in a previously obscure 2001, make that January 19th, 2001, Clinton administration pronouncement. The 47-page resolution letter that OCR and the Civil Rights Division forced the university to sign in May 2013 by threatening its federal funding required the school to treat as sexual harassment, quote, any unwelcome conduct of a sexual nature, end quote, including verbal conduct, that is, speech. Indeed, the letter required the school to treat even a single isolated incident of severe so-called harassment of one student by another as establishing a hostile environment and thus requiring the school to punish the alleged harasser. Worse, OCR explicitly included in its definition of sexual harassment even speech that would not offend an objectively reasonable person of the same gender in the same situation. Previously, Montana had a little provision saying it's okay if it offends if it wouldn't offend an objectively reasonable person, but that wasn't good enough for the Obama civil rights agencies. So the language implicitly encouraged Montana and other schools to discipline students and faculty members, even for perfectly reasonable statements or overheard jokes, whenever a hypersensitive or vengeful person might complain. The 2013 letter flouted the leading Supreme Court decision on campus sexual harassment, Davis versus Monroe County Board of Education in 1999, which had held that even severe harassment must also be pervasive and known to the school to create a hostile environment. The Obama agencies were so proud of this new high watermark and their attacks on campus free speech that they hailed the Montana Agreement as a blueprint for colleges and universities throughout the country. This blueprint was properly denounced by the Foundation for Individual Rights in Education for mandating that virtually every college and university in the United States establish unconstitutional speech codes and for making virtually every student a harasser. Meanwhile, with stunning chutzpah, President Obama was making multiple public statements posing as a champion of free speech on campuses. The Montana blueprint was so outrageous that it provoked a backlash even in politically correct academia. This prompted OCR to backtrack temporarily, but in 2016, it echoed the blueprint in a findings letter to the University of New Mexico, and various schools revised their policies to conform to the so-called blueprint. It's worth stressing, as Shep Melnick, who's here, has written, rather than using the standard notice and comment rulemaking procedures laid out by the Administrative Procedure Act, the Obama administration relied entirely on unilaterally announced Dear Colleague letters. Their use rests on the transparent fiction that these letters do not add requirements to the applicable law. This approach enabled the Obama administration, in effect, to impose very bad, ideologically extreme new laws on universities and their students and faculty with zero input from Congress and the public. I'll cite a few examples of the kind of censorship that the Obama civil rights agencies helped spawn in the name of fighting sexual harassment, the analogous problem of racial harassment, and other forms of unwelcome speech. At the 10-campus University of California system, the office of UC President Janet Napolitano set aside her professed devotion to free speech to urge deans and department heads to attend workshops on microaggressions. Examples given during the workshops of microaggressions included America is the land of opportunity, that's a microaggression, and the best qualified person should get the job. That's almost an aggravated microaggression. UC guidelines also prohibited, quote, questioning the validity of other students' stories, end quote. Might this prohibit an innocent professor or a student falsely accused of rape from calling the accuser a lie? Tenured Marquette professor John McAdams, a conservative, was suspended indefinitely without pay in 2014, and he's still suspended because he wouldn't apologize, for harassment for criticizing on his personal blog a graduate student instructor named Cheryl Abati. She had prevented a student in an ethics class from speaking against same-sex marriage while calling him homophobic. At Marquette, criticizing her for doing that was harassment. Russell Neely, who teaches subjects including politics at Princeton, listed the following communications that faculty are required to report, making themselves politically correct informers if anyone complains. These are quotes: sexual or gender-based jokes or teasing, comments about clothing, personal behavior, or a person's body, terms of endearment such as honey, dear, sweetheart, babe, references to an adult as a girl or boy, doll or hunk, and sexually suggestive looks. Harvard's code prohibits sexually suggestive innuendos and commenting about an individual's body. Women as well as men get put on trial by universities on sexual harassment charges, usually made by other women, that involve neither sex nor harassment. Consider Northwestern University's repeated investigations of liberal feminist film professor Laura Kipnis. In a February 2015 essay in the Chronicle of Higher Education, headlined Sexual Paranoia Strikes Academe, Kipnis mocked Northwestern sex policies, including a recent ban on faculty-student romances as feminism hijacked by melodrama. She also questioned a flimsy sexual assault complaint against another professor. For this, 2 women graduate students complained that the Kipnis essay, all by itself, had created a hostile learning environment at Northwestern University. I'm not sure whether Professor Reddish was affected by that, but apparently it was a big problem. And a campus kangaroo court put Kipnis through months of harrowing investigation. After she was vindicated, Northwestern investigated her again In 2017, this time for writing a book ridiculing its reprehensible first investigation of Kipnis for writing an essay. Now, you might say, well, they only investigated her, they didn't fire her, but an investigation is its own punishment often. There are countless such examples. Small wonder that a 2010 study by the American Association of Colleges and Universities found that over 80% of professors and 70% of college students doubt that it's safe to hold unpopular points of view on campus. The percentages would probably be higher now. Similarly, a 2017 survey of college students by the Heterodox Academy found that 53% don't think their school frequently encourages students to consider a wide variety of perspectives. Why, one might reasonably ask, have not the Obama OCR's flatly unconstitutional decrees been struck down by the courts? One reason is that OCR dodged judicial review as well as political accountability by using its administrative power and its media allies, the so-called list of shame of universities under investigation, rather than legal process to bludgeon and shame universities like Montana into signing settlements. And almost no universities dared challenge the agency in court. While universities have lost more than 70 rulings, mostly preliminary, and lawsuits brought by accused male students who had been punished by rigged kangaroo courts for alleged sexual assault or harassment, many more rulings than they have won. And of course, let me stipulate, yes, there's plenty of rapes on campus. I don't deny that for a moment, but there's also plenty of either false accusations or accusations that if you look at the facts, you ask yourself, so what was wrong with that? Two drunken people, for example, getting together. The universities have avoided Supreme Court review of their unlawful conduct by settling cases after losing preliminary rulings. For this and other reasons, the best hope for protecting free speech and due process on campuses is not lawsuits, nor is it legislation, given the reluctance of Congress to take on universities and the gender warrior lobby in the midst of the guilt-presuming Me Too movement. The best hope is Secretary Betsy DeVos. She has already ended some of the Obama administration's damage to fair process and free speech by rescinding Obama guidance documents and ending the practice of turning every individual Title IX sexual harassment complaint into a sweeping, publicized federal investigation of the entire university over the past 3 years. The reaction from Democratic politicians and the politically correct New York Times was hysterical. But interestingly, DeVos's actions drew cautious support from news media less extreme in their left bias than the Times. These included the Washington Post, the Boston Globe, USA Today, and The Economist, none of which had previously criticized the Obama attacks on free speech and due process. It took Betsy DeVos putting a spotlight on what was going on to force those newspapers to face it. The DeVos team has also invited, but not yet required, schools to adopt a standard of proof more favorable to accused students than the more likely than not standard required by the Obama administration. Most important, perhaps, DeVos has initiated an ambitious notice and comment rulemaking designed to adopt, probably in 2019, permanent binding regulations under Title IX for campus disciplinary proceedings for alleged sexual harassment and assault. The rulemaking is supremely important because DeVos's commendable efforts so far to end the federal government's hostility to campus free speech and due process without more will not go very far to protect constitutional rights. That's because the hostility to those rights of the universities themselves, or at least the people who have the power to make them act, and of blue state governments, including California's and New York's, remains strong. Most universities have left in place the guilt-presuming rules and overbroad definitions of harassment that many were all too pleased to adopt, as well as the legions of biased campus sex bureaucrats that schools hired on orders of the Obama administration. Harvard alone has more than 50. And I was reminded of this when Professor Reddish this morning so eloquently talked about how impartiality is the sine qua non of due process. Well, the fates of lots of people on campus were being decided by bureaucrats who were basically answerable to the Obama Education Department and were very, very far from being impartial. They could lose their jobs if they didn't find enough people responsible. Meanwhile, most universities and many student activists have become ever more ideologically skewed to the left and hostile to speech that the left does not want to hear and to fair process for accused males. According to studies released by the Heterodox Academy, across university departments in nearly all states, an average ratio of 10 to 1 exists among faculty who identify as liberal versus conservative. In addition, in recent years, perhaps the most potent attacks on free speech have come from student activists who equate speech that challenges their prejudices with physical violence. Indeed, a Brookings Institution survey in September found that 51% of college students, including 62% of Democrats, believe it's acceptable to silence a speaker known for offensive and hurtful students by shouting him down. 20% believe it's acceptable to use violence to prevent such a speaker from speaking. This prompts me to suggest what may seem a heretical proposal, at least to those here who are conservative advocates of deregulation. I call on the administrative state, specifically Secretary DeVos, to draft muscular new regulations, narrowly defining sexual harassment and related doctrines to protect speech. She should also specify rigorous trial-type procedural rules to ensure fairness and impartiality to both accused and accuser in all campus disciplinary proceedings involving sex, including cases in which the accused raises a free speech defense. These proceedings should include rights to timely notice of all allegations. None of these rights, by the way, are common now. Rights to a fair hearing before an impartial and independent panel, rights to have panel members instructed that an accused is presumed innocent until proven guilty by clear and convincing evidence, I would hope, and rights for both accused and accuser to have a lawyer or properly trained representative, cross-examine all witnesses, including the opposing party, to call witnesses, to a meaningful appeal of any adverse finding, and more. The Title IX predicate for these rules is that many and perhaps most schools have repeatedly violated Title IX by discriminating against accused students, the vast majority of whom are male. Such a finding could build on Judge Pierre Laval's important July 2016 ruling for a 3-judge Second Circuit panel, refusing to dismiss a student's claim of anti-male discrimination by Columbia University. Judge Laval wrote, quote, "A covered university that adopts, even temporarily, a policy of bias favoring one sex over the other in a disciplinary dispute, doing so in order to avoid liability or bad publicity, has practiced sex discrimination, notwithstanding that the motive for the discrimination did not come from ingrained or permanent bias against that particular sex," end quote. The kind of sex discrimination described by the panel seems more the rule than the exception on today's campuses. Now, I understand that the federal regulations I propose may strike many conservatives as an administrative state cure worse than the authoritarian leftist disease. I get that, and I wish I could think of a better way to protect the constitutional rights of independent-minded college students and professors. But I can't. The paradox is that nothing short of muscular federal regulation will stop politically correct universities from trampling the liberties of students and faculty indefinitely. Thank you. I'd be very glad to take questions. Sorry, I started to walk away. Yes.
Didn't come out of the blue. They follow on a culture of political correctness that our country has been discussing now for decades. And so your proposal strikes me as sort of trying to get healthy fish from contaminated waters. And on the proposition that this follows from a culture on campus that has been in place for so long. I mean, when did Alan Bloom write his book, or tenured radicals? I mean, this phenomenon is not new. So how do you address that more deep-seated cultural problem that is now the norm on college campuses?
Yeah. Very good question. And again, I wish I knew. Yes, it's been a deep-seated problem for a long time. I think it's gotten worse. The numbers show that the faculty ratio left-right is getting more and more lopsided. This whole frenzy over campus rape it's been going on, in some circles for many decades, but it went into overdrive during the Obama administration. One interesting thing my co-author Casey Johnson and I found, we wrote the recent book and the 2017 Duke lacrosse book, 2007, is that although we thought the students at Duke were fairly sane compared to their faculty and administrators and university president in not rushing to judgment against the accused, at the University of Virginia 10 years later, when it was the Jackie fraud, the students, as well as the administrators and the faculty, were all, not all, but by and large predominantly part of the rush to judgment mob. That and other input has suggested to us that the brainwashing that we think has been going on for a long time has really taken hold, maybe in the last decade or more, to an extent that we hadn't noticed before. But you're very right. A few rules by the Department of Education are not going to make a sick university culture healthy. I think it's better to have them than not to have them, and I'd love to hear any proposals for the deeper problem. I'm not sure how to do that. Yes.
So while disclaiming expertise on the educational system, I have a suspicion that one of the problems here is how we accredit universities and how the accreditation agencies are all regional and all captured by the same forces that we're talking about. And sort of a partly regulatory, partly deregulatory solution would be to either get rid of the monopoly power of these accreditation agencies and have the Department of Education perhaps have a direct accreditation standard, which would include intellectual freedom and due process among the factors, as opposed to currently, I think the accreditation agencies only look at the politically correct factors: how many minority faculty do you have, how your Title IX compliance, and so forth.
I think you're absolutely right. And in fact, as you may know, Rick Sander and I put a chapter in a book we wrote on affirmative action, racial preferences in 2012, about George Mason's law school. And in a nutshell, George Mason's law school was having a problem with, they had a big affirmative action plan, at least for a while. They were having a problem with grades and bar passage of the people who came in with substantially lower educational credentials than their classmates, and a big problem with bar passage for those students. And therefore, they cut back dramatically on racial preferences, which had the effect of cutting back dramatically on black admissions. And they were taken through the ringer by the accrediting body, the American Bar Association, to the point that their accreditation was at risk, and they went back to very heavy preferences. And as a result, they went back to big problems with bar passage. And I think the American Bar Association and a lot of other bodies, it's interesting, the American Law Institute is having a big struggle over whether to import into the criminal law the same kinds of guilt-presuming processes that the colleges have been using. So I think you make a great point. Yes.
Just to fill out the story about Northwestern in response to the Kipnis situation, the Faculty Senate appointed a committee, of which I was on, my colleague Andy Koppelman, who writes on free speech, and a couple of other parts of the university faculty members were there, to redraft or to draft a speech protective provision for faculty publications and faculty writings. And that we did that last year. And so now the university has a much more, at least faculty protective approach. We didn't deal with student speech.
And you think that'll stick? I mean, it's not going to get washed away by the next student protest that occupies the president's office?
of a hope springs eternal. Say.
Thanks. Was there somebody else? Yes, sir. And yes, ma'am, after him.
Hi, my name's Elaine Middleman, and one of the people that you wrote about, his dad was at IU with me. I was just telling him he played in the Rose Bowl. You probably know who I'm talking about. Anyway,
I
so
think I do,
very
yeah.
much appreciate your work
Yeah,
on that.
yeah. No, I thank you very much.
I should add that was 1967 Rose Bowl, 1968, 50 years ago. Help.
Now, did you say IU?
Indiana University.
Oh, yeah, but not this. He came up in the Duke case, right?
It was the father of one of the three.
Right.
Right.
Yeah, David
Dave
Evans. And
yes.
his son was David Evans. And
Right.
I don't know if any of you saw the very good film that ESPN put on about the Duke lacrosse case, but the indicted son, David Evans, gave an amazing talk from the steps the day he was indicted that I think turned around a lot of people's impressions of what had happened.
Well, I mean, like I said, I went to college with the father, and he was about the most respected person on IU campus, so that was pretty shocking.
Good.
Very hard on the family. I could
Oh, it's terrible, but they're strong.
Anyway, I was rethinking about the Duke. What led to that culture and environment, and the Nifong thinking he could prosecute people like that? I mean, that's just mind blowing to me that developed so terribly.
I think that although Duke is notoriously perhaps more PC than most, I think that same thing had happened at Princeton, my alma mater, a lot of other places. If the same facts had unfolded, there would have been a similar reaction. And to make it a little more understandable, here was a white district attorney who previously had a decent reputation, screaming at the top of his lungs that these terrible, privileged white lacrosse players had horribly raped and beaten this poor black woman. And so, it was a little bit natural for people to believe him at first. Why would he make that up? Well, he made it up. He lied about it for various reasons, one of which was to win an election. But what was harder to understand was the evidence proving the falsity of the charges came out over time, and within a month or two into the case, anybody who was paying really close attention knew that this was probably a fraud. But the faculty and the administration of Duke and the national media, led by the New York Times, didn't notice that. They paid no attention to the evidence and kept rushing to judgment to the end. And although something close to 100 Duke faculty members, the so-called Gang of 88, Group of 88, I think, signed a guilt-presuming letter at the beginning and were called upon after it was proven false to apologize. Not one apologized. Yes. Do we have one? What? There's a hand.
Thank you very much for your comments. One of the things that strikes me about Title IX is that it's a conversation that's been captured by a public conversation, and some of the work that obviously that you did and the Rolling Stone piece showed some of the problematic aspects of it. But then we see more recent events. This physician in Michigan State, who I think basically slipped through a Title IX investigation. So it seems like, is this because of the topic so sensitive? Is it something that we have a concern where the regulatory regime kind of goes back and forth by virtue of what's in the public conversation at this particular moment? Does that make sense?
Good question. And my co-author, Rick Casey, and I gave a lot of thought to this. There are cases, I mean, if you go back to the 60s or 70s, there was a pervasive realm of denial about this, and women who were raped, got it swept under the rug, and all the horrible things that are still alleged to go on at campuses were going on. Over time, that's changed a lot, but there are some areas where it hasn't changed. The Michigan, I think, here was this doctor, this monster as it appears. He was bringing a lot of glory to that college and a lot of money. And parents of girls who wanted to be in the Olympics, I think, even the parents and the faculty people, they had certain incentive to look the other way. The same is true at the big football and basketball programs. When people at, say, a place like Baylor, although I'm not sure they're all guilty, get accused, there's a lot of favoritism still for the accused male if he happens to be a $1 million football player. But you know, I think one thing that's a myth is that this preference for men, this discrimination against real victims, which was very real in the 70s and 80s, that it was the rule, not the exception, right up until the Obama administration. And in fact, I think the things had shifted in the direction of presuming guilt long before the Obama administration. The Obama administration accelerated that. And